I've got 1:47 on my clock, so we're going to try to get rolling. We got a lot of turf to cover. It's a pretty full room, and we're grateful for you being in here. I'm sure it has nothing to do with the ethics CLE that you'll get for your attendance, but instead is this exciting topic and esteemed panel. We're going to be talking for the next 75 minutes or so about ethics issues confronting lawyers in criminal investigations and enforcement cases and internal investigations, and we could not have a more esteemed panel to carry us through that conversation for the next 75 minutes. My name is Zach Farden. I'm a partner with King & Spalding in their newly minted Chicago office, and I have the honor of moderating this panel this afternoon. I'm going to quickly introduce them, and then we're just going to jump in and talk about some of the current issues that are recurring ethics-wise for lawyers in those kinds of investigations and criminal enforcement cases. So whenever you have a federal district court judge on your panel, the first conundrum you have as a moderator is whether to introduce him or her first or last. Because if you introduce him first, then the judge is thinking, well, most folks think you saved the best for last, so this guy must not think I'm the best. But if you wait and introduce him last, then while you're introducing everybody else, the judge is thinking, what's this guy doing and when is he going to get to introducing me? So we're honored to have and lucky to have the Honorable Noel Hillman to my far left from the District of New Jersey. Judge Hillman was appointed by President Bush in 2006. He is a native of New Jersey, a graduate of both Seton Hall and NYU law schools where he obtained an LLM. He clerked for a district court judge. He did a stint in private practice, and he then served for nearly a decade as an assistant U.S. attorney in the District of New Jersey before he transferred to Main Justice and served in various leadership roles, including as chief of the Public Integrity Section, a section near and dear to my heart. Judge received as many accolades as you can and awards as a prosecutor and is equally respected on the bench. So it's a real pleasure to have him. The rest of the panel is equally esteemed. To my far right, we have Sandra Mosier, who is the chief of the fraud section within the criminal division right now. Before that, she was the principal deputy chief. She's been in the fraud section since 2012. Prior to that, she spent 6 years as an assistant U.S. attorney, also in New Jersey. This is like a Jersey Shores episode we're having up here.
Not quite.
Hopefully not.
Not yet.
Maybe not quite that exciting is what you're saying. The ethics should be a little bit different anyway. So before that, Sandra also did some work in private practice, I think both with Drinker Biddle and perhaps Morgan Lewis. Is that right? She clerked for the Eastern District of Pennsylvania as well as the Third Circuit. And she is, most importantly, a graduate of Northwestern Law School in my backyard. So go Cats. To her left is Erica Williams, who's a partner at Kirkland and specializes in internal investigations and defending companies and individuals in criminal cases and enforcement cases. Before that, Erica spent about 11 years with the SEC, where she was initially a trial attorney in the enforcement section and went on to various leadership roles, including deputy chief of staff, I think, to 3 different chairmen, which is to say she is both smart and very patient. She also served in the White House as a special assistant and associate general counsel for President Obama. She is a double UVA grad, so go Cavs. Go Cavs as well. Well, the Cats don't get applause, and the Cavs do. Okay. So last but certainly not least, to my immediate left, we have Billy Jacobson. He's a partner at ORC, and Billy has really done it all. He's been a prosecutor, a defense lawyer, and a general counsel. He spent 5.5 years as the general counsel of Weatherford International, which is one of the world's largest multinational oil and natural gas companies. Before that, he also worked at Main Justice in the fraud section, where he was a trial attorney and eventually helped lead the FCPA enforcement section. Started his career as an assistant district attorney in the Bronx, no less. Has also done stints as a partner with Kirkland and with Fulbright. Billy is a graduate of Georgetown Law School, and I still don't really know what a Hoya is, so I'm just going to avoid that altogether. But this is a great panel. Let's give them a quick round of applause, and then we'll jump in. So late last year, Judge Howell in the Office of Special Counsel Investigation, the Muller Investigation, entered an important order in which she essentially required a lawyer to provide evidence against that lawyer's clients, and Judge Howell reasoned that the crime fraud exception applied and that privilege had been waived. The client had essentially provided information to the lawyer to then provide to and mislead, the opinion found, the Department of Justice, and thus the crime fraud exception applied. Billy, you want to maybe set the stage for us a little bit in terms of what the facts behind that order was and what the court's basic reasoning was?
Sure, as briefly as possible. So the special counsel's office sought testimony from Paul Manafort's counsel regarding letters that counsel sent to the DOJ's FARA unit, the Foreign Agent Registration Act unit. And the letters concerned the scope of Manafort's representation of certain clients, in the special counsel's opinion, downplaying the scope of the representation both generally and in the United States as it would impact the FARA legislation. The special counsel's office served a subpoena, a grand jury subpoena on counsel in August of 2017, which counsel, as you would expect, objected to on the basis of the attorney-client privilege, work product privilege, and based on the rules of professional conduct. Special counsel's office argued that whatever privilege existed had been waived, and to the extent it hadn't been waived, were subject to the crime fraud exception. The special counsel's office listed 8 different topics about which it wanted to ask counsel in front of the grand jury, all related to these FARA submissions that it contended were fraudulent. And fast forward to today, that subject matter is included in Manafort's current indictment. So most of the topics that the special counsel's office listed as wanting to inquire with counsel about were with regard to the sources of information, the information that went into the FARA submissions. What was the source of that information? The court found, after reviewing evidence ex parte, that the special counsel's office had met its burden in showing that the crime fraud exception does apply because Manafort and his then co-defendant Gates were engaged, according to the court, in a criminal scheme or a fraudulent scheme when seeking advice, and were using that advice to further the scheme. So the crime fraud exception applied. The court also ruled that communications that led to the drafting of those letters to FARA were waived. The privilege over those communications were waived. And this part of the opinion gets a little tricky, and it's not entirely clear. We were talking about it earlier this morning. It's not entirely clear the basis, to me anyway, the basis for the judge's finding in this regard. It might be because, and the court does mention the fact, that the letter itself attributes certain statements, and according to the court, many statements in the letter, to the clients. And so there's not a copy of the letter, at least I haven't seen a copy of the letter, but the way the court describes it, it makes it sound as though the attorney basically said, my clients have told me X, my clients have told me Y. Those statements are in the letter. So the court found that the communications that counsel had with her clients regarding the subject matter of the submissions was waived entirely, subject matter waiver, which is sort of interesting to me and seems a little broad, frankly, to me, although it could have been because she attributed the client's communications directly in the letter. In any event, that was the court's finding. The one question that the court did not compel counsel to answer was whether she had memorialized the conversations that she had with her clients regarding the FARA submission. And the court found that that would constitute opinion work product because that would indicate the counsel's mental processes, things that she found important enough to take notes on would indicate her mental processes. And so the court did not allow the special counsel's office to ask questions in that regard. So that sort of sets the stage. The opinion is, go ahead.
No, thank you, Billy. Judge Hillman, let me just ask your views about the sort of ethical and privilege implications of this opinion. Obviously, this lawyer was put in a position of then having to testify in front of the grand jury based on letters the lawyer had written on behalf of her client. What do you think that means from the perspective of advice lawyers might give going forward and or their relationships with their clients?
Thanks, Zach. First, I think we ought to be clear that, as I understand it, and I don't know who the lawyer was. I don't know if it's been publicly disclosed, but there's no suggestion that I have heard or read in the opinion that suggests that the lawyer knew that the statements being made
Correct.
to the Ferry unit were false.
Good point.
So for me, this case represents a tension between two really very important basic principles of lawyers' ethics. On the one hand, we want lawyers to be vigorous and zealous advocates for their clients. There's a whole series of rules of professional conduct that address that: loyalty, diligence, confidentiality. We expect lawyers to have fidelity to their clients. And the general counsel from Pfizer yesterday at that particular session said, you know, I want lawyers who fight for me, who believe in the cause. And on the other hand, there is this very clear rule, Rules of Professional Conduct 4.1, that requires lawyers, when they're making statements to third parties, to be truthful in all regard. The rule specifically says, quote, in representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person. So I see a tension between those two things: vigorous advocacy on the one hand and the obligation to be very careful in what you say to third parties. In terms of privilege, I think you have to raise the question about how this plays out in the world we live in today, in which we basically live in a regulatory state. Lawyers are constantly responding to inquiries from regulators, advocating on behalf of their clients. If lawyers feel that in that effort they are placing the communications they have with their clients or their work product at risk, I think that can have, one would expect that might have a chilling effect on how they approach a regulator, or even if they approach a regulator at all. Yet the rules of professional conduct say a lawyer may counsel or assist a lawyer in a good faith effort to determine the validity, scope, meaning, and application of the law. And I think you can make a pretty good argument that this is what Manafort's lawyer was trying to do. So the case arises in kind of an interesting factual circumstance, because the Ferry unit is, we don't normally think of DOJ as being a regulatory agency, but at least as it relates to that particular unit, it is. But think about a client, a financial institution that's dealing with state regulators and FinCEN and OCC and all of those. So, you know, my view is that, and I would say that, you know, in the regulatory environment, we really want to encourage dialogue. We want lawyers to write letters. We want them to engage with the process to allow for the process to result in compliance. We shouldn't live in a world where it's basically a game of gotcha, right? So, and it's interesting, if you look at the opinion, it focuses on two letters that were written that were deemed, based on the ex parte proffers to the court, to be false. But the opinion also references a third letter, and it's quoted to the effect that, based on our conversations with the Ferry unit, we've decided to register. So it's no place for me to comment on the guilt or innocence of Paul Manafort, but if you look at this from 50,000 feet, the compliance process, in one sense, actually worked, in the sense that eventually, after seeking advice, interacting with the Ferry unit, he complied with the law, and ultimately that's what we want.
So Judge, well, let me ask both Billy and the rest, anyone else who wants to weigh in on this. I mean, obviously, as lawyers, all the time, we are writing letters and memos and white papers, sometimes to the government, and with DOJ, not typically in the regulatory context, as you point out, but often in the enforcement context, and often to try to assuage or appease prosecutors, convince them not to prosecute our clients. And of course, almost inevitably, some, if not most, of the information contained in that white paper or that correspondence will come from our clients. Is there a risk of subject matter waiver based on this opinion? What are the practical kind of recommendations that we can make to this group about what they should make of and do with that opinion, if anything?
Yeah, well, I'll go first if it's okay. I think it would be a real stretch, and hopefully not the law, that any communications that you have with your client that form the basis of statements you put in a white paper or a letter or a pleading amounts to a subject matter waiver, because that would be pretty much everything, I think. Most of the factual information that you get, if you're representing a company, for example, is coming from someone in your client, someone at your company. So it would be really an incredibly broad waiver. And so I like to think, and again, to me the opinion's not crystal clear on this by any means, but I like to think that the court was hanging her hat in that regard on the fact that the letter referred to the communications with the client and said something to the effect of, I'm informed by my client that, which makes a lot more sense that that would cause a subject matter waiver. And to bring it into more immediate terms for me, I encountered a similar situation just last week where when drafting a letter with a co-counsel in another country, the original draft of the letter said, we are instructed by our client to tell you X, we are instructed by our client to tell you Y. And to be frank, I hadn't read the Manafort opinion at that time. But intuitively, it struck me as not a good idea to phrase the letter in that way, even though it was really just his manner of writing, really just a stylistic thing more than anything else. So we edited the letter to just sort of say what we wanted to say instead of referencing the communications and the instructions that we got for our client, but to avoid this exact problem.
So also late last year, Sandra, another important opinion came out from the Southern District of Florida in a case called SEC versus Sandoval, where a law firm had done an internal investigation, conducted a number of witness interviews, and then offered a oral download, is the term that was used in the opinion, to the SEC in connection with a slew of those witness interviews. And the court found that that privilege had been waived as to all of the underlying materials associated with those interviews. Can you talk for a minute about that case and the rationale for that case?
Sure. For those of you who don't know the facts of this case, and first raise your hand if you can't hear me. Hopefully you can. As Zach said, this is a major law firm, as many do, and many of you in this room do every day, was conducting sort of a multi-pronged investigation, one that involved both the SEC and the DOJ, an internal investigation for a large manufacturing client, and in the course of an attempt to be in a cooperative posture, provided facts and oral downloads of certain witness statements to the SEC. And when the SEC ultimately sued the former CEO and CFO, I believe it was, of the company, those individuals, in their bid to defend themselves, subpoenaed that law firm, who had obviously collected a lot of materials and provided information to the SEC over the course of years. And those individuals said, basically, the SEC is our adversary here, and they've benefited for a number of years from this information that's been collected and shared by the firm, and we want it too. And by the way, there is no privilege there because you disclosed this to the SEC. The law firm said, no, there is a work product privilege here, and we should benefit from its protection. And as Zach indicated, the court, this is a magistrate judge out of Miami in the Southern District of Florida, disagreed and said, essentially, you should give over the notes and the memoranda that relate to those oral downloads that you gave, because the oral downloads are the functional equivalent of those written materials. And the real focus for the court was on the party to whom the material or those facts or those downloads is the party that is receiving that information. And in this case, he said it's clear it's the adversary. You're in an adversarial position, unlike an auditor, which was another piece of the opinion. The court found that the auditor who had received similar information was not required to give the defendants in the matter that material. But the law firm was. And that's significant for obvious reasons. There was subsequent the motion practice in which the law firm attempted to get some clarification, as they termed it, regarding the scope of the judge's order. And they made the point that really the best evidence were the notes that were actually taken at the time that the oral downloads were given to the SEC, because of course I'm sure there was an associate there, somebody again taking notes, not the original notes and memos from the witness interviews. Interestingly, ultimately the SEC and the individuals who are requesting the information reached some sort of agreement that frankly is not public. And I know the terms, I can't talk about it, unfortunately, but they've worked something out. And I think there was some recognition of the fact that while the court felt certainly the topic and the subject of those oral downloads and those particular witness interviews, certainly as they were relevant to the accounting fraud that was charged against these guys, as opposed to other aspects of the investigation, most likely including the department's criminal investigation, might still retain their privilege. Although, to Billy's point, and depending on how broadly you might read the grand jury opinion in the special counsel matter, not that it's in the same district, but there's a lot of extremely broad black letter law sort of cited as they set up the arguments in that opinion that could be read to really broadly, go all the way from this sort of ultimately narrow set of materials that this firm had to turn over down in Florida to a full subject matter. Yeah. So while that opinion I think seems harsh in Miami to some, if you look at it against the backdrop of the grand jury opinion, it could have been much worse.
Yeah, I mean, nonetheless, two very significant opinions around this same issue, at least in part, coming out late last year. And obviously this panel is focused on ethical issues for lawyers. Eric, I mean, from a practical perspective, what can or should we take away from this opinion, the Sandoval case and this waiver issue, and what, if anything, is left in terms of what defense lawyers can do to represent their clients vis-a-vis regulators and enforcement lawyers in terms of making disclosures? Is it inevitable that waiver is going to occur, or what can we do to avoid it?
Sure. So Judge Goodman's decision in the Sandoval case does present a real conundrum actually for corporations and their counsel, especially in this wave of where the government wants you to cooperate in order to be able to get credit. So here is a calculated risk as to how much information to provide to the government, which Judge Goodman decided was the opponent in this case, in order to provide cooperation credit for your client. Interestingly enough, in the opinion, the judge distinguished cases in which counsel provided vague impressions, conclusions, and general impressions about the case that were not facts, that were not specific, and said that those were distinguishable from this case where they gave an oral download and it really just came from the actual interview notes. And she also found that a PowerPoint presentation that defense counsel created for the SEC that included facts and chronologies did not count as work product, and found that there was no work product waiver there. So it's really sort of a calculated risk. How much can you provide to the government without waiving work product? In my opinion, you should be thinking about non-mental impression, non-work product facts. And I think that the part of the decision that is helpful is that PowerPoint presentation that they created, where she found there was no work product protection that was waived.
Okay, so Judge, we'd be remiss. Billy, do you want to weigh in?
Yeah. Just as a practice point, I've had a fair bit of success getting both DOJ and the SEC, and this isn't rocket science, but to agree to no subject matter waivers with regard to the revelation of material that would otherwise be privileged. And so you're waiving, to the extent you're giving those communications over or relaying the substance of those communications over, there's no question that the privilege is waived as to what you are saying to the DOJ and the SEC. But I've had good success getting the DOJ and the SEC to agree to a no subject matter waiver, no further waiver. So the stuff that might underlie what you are providing and what you are waiving, they've generally agreed that that other stuff is not waived just because you're producing the first batch of stuff. And that will provide you a protection with regard, like in the Sandoval case, to the SEC or the DOJ claiming you've waived further than you intended to. It won't, of course, protect you from third parties claiming that you've waived based on subject matter. And so if the company is subject to derivative suits or securities fraud suits or what have you, those plaintiffs, if they're savvy enough to ask the right questions, may well determine that you provided a lot of information to the DOJ and the SEC and claim that you've waived privilege over the entire subject matter. Your agreement with the SEC and the DOJ will only protect you vis-a-vis the SEC and the DOJ, which is certainly something, but it's not everything because it won't protect you with regard to the third parties.
It's a great practical tip and one you should pursue if you can, but in other words, it all comes down to the court at the end of the day, which is why, Judge, we'd be remiss if we didn't ask, when you address these kinds of privilege issues and waiver issues, how do you approach that kind of problem from the bench?
So I would say my approach would be very similar, if not identical, to how Judge Goodman did it in the Sandoval case and Chief Judge Howell and the other case we were talking about. You kind of start with the basic principle of how important this privilege is and how it's a bedrock, really, of our adversarial system. The system, our adversarial system, I would say, breaks down if we don't have, at least start with the presumption that would be an extraordinary set of circumstances in which we would breach the privilege. I've got 400 and something cases on my civil docket and a couple of vacancies in my district and 2 in my courthouse. So, it'd be really easy if I could bring in the lawyers and say, tell me what you told your client was the most vulnerable part of your case. I could wipe, or better yet, what if we just waterboarded the clients and then I could really find out what happened and I could get 200 cases off my, that's a joke, by the way. So, kind of start with the principle that this privilege is really important. And then the next step is to kind of make sure that you understand the nature of the materials to determine whether or not the privilege actually applies to the materials, whether it's the attorney-client privilege or the work product privilege. Sometimes the scope of the privilege is not as narrow as perhaps the lawyers might want you to believe it is. And then you kind of walk through the exceptions. Was the communication, back to the earlier point, for example, if the communication was not meant for the purpose of, was not from the client or was not meant for the purpose of soliciting advice in anticipation of litigation. And then you want to walk through the exceptions. Is this intended for communication to a third party? Was it actually communicated to a third party? Or are issues of fraud or concealment, the crime fraud exception apply? And then you go to this catch-all, which I've written an opinion on this. I have some concern about it, and you see both the judges in the cases we were discussing address it. And it applies really in the cases I've read in any event, in the arguments before me, both to the privilege, the attorney-client privilege, and also work product materials. In New Jersey, it's known as the Kozlov test. And here a party seeks to pierce the privilege by demonstrating a legitimate or in some jurisdictions a substantial need for the information, whether or not the information is relevant and material, and lastly, whether the information could not come from a less intrusive source. There was some argument, for example, discussed in the opinion in the grand jury matter that the underlying information concerning the scope of the representation of a foreign agent was known to the special counsel, and there was nothing about the communications with the lawyer that would shed any new or additional light on that. In the Sandoval case, many of the witnesses who had been interviewed by Morgan Lewis were in Brazil, and the individual defendants sought that information because of the difficulty of the letters rogatory process. So it's not it's certainly a colorable argument under some circumstances, but my concern is that when lawyers say, I need this, judge, what they really mean is, I want this, judge, and because it's going to help my case. And as I say to my kids often, there's a difference between need and want. And just because you really want it doesn't mean you actually need it. And my sense is that this particular test, if applied too broadly, basically becomes the exception that swallows the rule. So I'm skeptical of that and critical about it in the sense that I want to know more. I want to know how it actually relates to a claim or a defense. And I really believe it's a narrow set of circumstances where that test will allow one to pierce the privilege. An example would be a lawyer advises a client on a settlement, and then the settlement is not consummated and there's a dispute about the scope of the settlement, for example. That narrow set of circumstances seems to me to be what this particular test is designed to get at. And lastly, I think even if you decide that you're going to pierce the privilege, that you want to make sure that you do it in the narrowest possible way, to tailor the relief in a way that minimizes any unintended consequences, because of the importance of the privilege. And I think you see this in both the grand jury case and also in the Sandoval case. I may have a slight disagreement with Billy and Senator about the subject matter waiver in the grand jury case. It's absolutely clear that the judge cites a lot of D.C. law for a standard that suggests there's a substantial risk of subject matter waiver. But the ultimate order of the court is to a very narrow set of questions, and I think some credit should be given to the special counsel for not asking for too much. They were very clear, this is all we want. They were very tailored in what they surgically done. And so, you know, I think as a judge, you want to do the same thing. You want to make sure that if there's a basis for it, you allow it, but you make sure that you don't, in essence, do more harm than you should. And you see that in Sandoval, where the judge said, I'm not going to give you the witness statements of the witnesses overseas.
So, thank you, Judge. I just want you to know when I ask Your Honor, tell you, Your Honor, I need the information. I really do need it.
Okay, all right.
So let's pivot and talk about ethical issues.
And you saved the best for last
Yeah,
as
I'm
well.
just right. Touche. Let's pivot for a minute and talk about ethical issues in internal investigations, because there are so many in the recurring, and we want to sort of get the fresh perspective on those, starting with the common question of who should conduct the investigation. There are always cost-based considerations about internal counsel versus external counsel for conducting internal investigations. But what are the ethical issues that you got to think about in making that assessment? Billy, do you want to take that on?
Sure, I'll start. So when I was in-house, one of the first things I did, it was a company that was under investigation and was spending a lot of money on outside counsel, legal fees and forensic accountant legal fees and so forth. So the first thing I did was form an in-house internal investigations unit to hopefully save money and not have to send all the investigations to outside counsel. And I think that proved to, in fact, save a lot of money over the course of time, although the initial investment, of course, is expensive, but nevertheless. So my view is that doing internal investigations in-house the vast majority of the time is the way to go. It's tremendous cost savings in terms of not having to pay outside counsel and outside forensic accountants and so forth. It's also a tremendous cost and a tremendous time saving in the sense that you've got this, if you have folks in the company who are competent to do it, they build up this knowledge of the company and of the business sector that, as much as you may rely on one particular law firm, you can't mirror compared to someone who's working in the company. But that is a key point. They have to be people who are competent to do it. And if you wind up before a regulator on one of these investigations, and the regulator feels that you were relying on in-house counsel, but people who didn't know what they were doing and weren't properly trained and resourced, et cetera, that's not going to buy you much goodwill. So the folks doing it have to be well-trained. They have to be very competent. But also there is a limit, I think, getting to more of the ethical issue. I think there is a limit to the type of investigation in-house counsel can do. Because if the investigation gets to the level of the C-suite, certainly if it gets to the level of the board, and people in the C-suite and people on the board are implicated in the investigation, you're really going to have a hard time, in-house counsel is really going to have a hard time being as objective as a regulator, as Sandra, for example, will want them to be. Because as much of a Boy Scout or a Girl Scout as the in-house counsel thinks they are, they also have to worry about their own job security or the raise that may or may not be coming, the promotion that may or may not be coming. And we don't want to necessarily rely on the valor of all of the in-house lawyers. And so my recommendation is that when an investigation involves allegations against the C-suite, and even maybe a level or two below the C-suite, depending on how the company is organized, then outside counsel be called in. And just to go one step further, I think it might be wise to recommend to companies to have a protocol that sets that forth, so that it's not sort of left to happenstance as to how the investigations are going to be handled and when outside counsel will be called in and when they won't be called in. Because again, if there's no protocol that's established before an allegation comes in, there could be pressure on the in-house counsel not to call in outside counsel for the very reason that one should call in outside counsel. So I think it makes sense as part of a company's normal compliance processes and procedures to have an investigative protocol that outlines, and you got to build in some degree of flexibility, but also draws clear enough lines on when outside counsel will be brought in.
Very helpful construct for thinking that through from somebody who's been both a GC and a defense lawyer and a prosecutor. So Sandra, once you've assessed who's going to do the investigation, then there's a question of how, including how will information be communicated, if at all, with the government, with the regulator. Do you have thoughts about that issue and the ethics impact of those
Sure.
decisions?
I mean, unfortunately, I can't offer too many answers because I can't, from where I sit, really dictate how things are done. But I can share my thoughts, and I would be remiss if I didn't add that today these are my thoughts and my views, and not those of the entire department, of course. Look, how to collect and then how to communicate facts that are learned during an internal investigation is extremely consequential. And cooperative companies want to provide, hopefully, complete and meaningful facts to investigating authorities, whether the regulators, whether it's the department. And of course, those authorities want to receive facts that are meaningful. And, you know, from my perspective, what I most want is usable facts, facts that I might be able to actually use and actually might be admissible evidence in a case if I'm, you know, pursuing an individual prosecution. So obviously, as we're touching on across a lot of these different topics today, that can create a real tension in terms of reporting results of an internal investigation. So, I mean, look, what the firm, of course, did in the Sandoval case that we're discussing is extremely common. And everybody up here has done it or been on the receiving end of it. And I think maybe it was Billy before who said, interestingly to me, you know, of course, when you do it the way it was done there's no question, and correct me if I'm misstating this, that there's a waiver there. But a lot of firms come in to us, at least at the fraud section, and hedge and try to walk the line, and they offer information or witness downloads like those discussed in Sandoval in a quote-unquote hypothetical way. You know, hypothetically, if you ask Erica, you know, if you were to ask her, is the sky blue? You know, hypothetically, she would say, yes, it is, or no, it's not. And, you know, reasonable minds, I think, can differ as to whether that does actually function to maintain the privilege. But I would say, I think the sort of tie goes to the runner. If we, sitting on the other side of the table, are not expressly saying either it does or does not so function in our view. And so I think that's something that's been going on a long time. And the question for me becomes, you know, a question of greater relevance for me in those situations is, you know, therefore, what if any real utility is there for me as an investigating authority to receiving that sort of information? If it's couched that way and therefore it's not usable to me.
Meaning hypothetical proffer.
A hypothetical, yes, exactly. And I would argue in a lot of instances it's extremely limited. And so at this point, you know, now in the fraud section, our attorneys are instructed that they're not going to, without supervisory approval at least, accept that sort of hypothetical download, and that it should only happen in the narrowest of circumstances. Because, of course, if we receive information, it's got to be turned over in discovery, and that's fine. But if it's not something that we can ever affirmatively use in a way that assists us, that's not fine. So, you know, I don't think that practice interferes or inhibits any company's ability to get cooperation credit. But, you know, circling back to the original question, it's, you know, there can be a tension there, and it's of great consequence, you know, for both parties involved, how information is collected and therefore ultimately communicated to the government.
So thank you for that. And backing up from defense lawyer, big picture perspective, I think a key takeaway from this entire conversation is you have to educate and talk to your clients about the risks when you're having communications with the government or with regulators, whatever the level of detail or substance, and there are ways you can and should be thoughtful about that. There is risk there in light of these recent opinions, in light of the department's view that I think clients need to be educated about as you move down that path. Switching to another recurring ethical issue when you're doing internal investigations, the issue of who's your client and taking on multiple representations. The model rules do allow for a lawyer to represent both the corporation and one or more executives or employees. But is it a good idea or not? And does the recent Yates memo emphasizing corporate criminal responsibility change that sort of analysis when you're looking at multiple representation issues? Erica, do you want to offer some thoughts on that?
Sure, Zach. So, as Zach said, multiple representation of both the company and executives and employees in the company is permitted under Model Rule 1.13. And then Model Rule 1.17 says that if there are concurrent conflicts of interest, you can still have multiple representations, but they have to meet one of the exceptions. And the 4 exceptions include that the lawyer reasonably believes that they will be able to provide competent and diligent counsel to each affected client. There are no, the representation is not prohibited by law. The representation does not involve one client making claims against another client in the same litigation or action before the tribunal, and each affected client gives their consent to the multiple representation. And notwithstanding, the fact that you may meet those criteria, it may be prudent to get separate counsel in certain situations for executives and employees. And especially after the Yates memo, which provides that in order to get cooperation credit, companies need to be able to provide all relevant facts related to individuals who are involved in the misconduct. That really does sort of tip the scale and put a lot of weight on attorneys having separate representation for executives and employees versus the corporation, because the corporation, in order to get cooperation credit, now has an incentive to provide information about employees. And you can imagine in a circumstance where one of the employees or executives has possible exposure, either criminal or civil exposure, and the company wants to get cooperation credit by providing all relevant information about that individual, that there is possible conflict there that would counsel in favor of having separate counsel for the corporation and employees. And the other fact I just wanted to, or consideration I wanted to mention, is it also can be beneficial to have separate counsel for the executives and employees in trying to build credibility with the government. Because then the government will know that the corporation is not trying to interfere and somehow inhibit the government from obtaining information for the employees because they have their own counsel.
Yeah. So what about the role of pool counsel? I mean, oftentimes in investigations, there'll be a counsel that's representing the company and then another external counsel that'll represent a group of individuals who are called before the grand jury or otherwise interviewed in connection with investigation, what we refer to as pool counsel. Does the Yates memo and that new paradigm affect that at all? I don't know, Billy or Erica, if you have thoughts on that.
Sure. I don't think so. I think pool counsel, when properly used, in my opinion at least, is for witnesses who are generally going to be just that. They're just going to be witnesses. And company counsel will have the ability, hopefully be smart enough about the case before they have to make that decision, to only assign pure witnesses to the pool counsel, and thereby minimize the idea of pool counsel potentially having any conflicts or any conflicts developing. And so if it's a pretty safe bet, and of course there's no guarantees, but if it's a pretty safe bet that the clients of pool counsel are in fact just witnesses, then I don't think the Yates memo becomes a problem, because you basically wouldn't have to be serving those folks up.
Of course, you don't always know on the
Sure.
front end who's going to be a witness. Yeah, go ahead.
And
Erica.
with respect to pool counsel, sort of the same consideration would apply with respect to the government feeling that you're not trying to impede the investigation because the witnesses, the employees, have their own counsel. It might also encourage employees and witnesses to be more forthcoming, because now they're not just represented by the company's counsel, they have their own counsel.
Yeah, That's a great point. So another recurring issue, Upjohn warnings, and obviously folks in this room are familiar with the warnings, which are both designed to give witnesses a sense of the nature and scope of the representation, but also to preserve privilege. What are, Billy, if I can kick it back to you, the legal and ethical underpinnings, and does the Yates memo have any impact on the importance of Upjohn?
Sure. So in terms of the legal underpinnings, it all started with a Supreme Court case called Upjohn v. U.S., which, interestingly enough, makes no mention of warnings whatsoever. But in Upjohn, the Supreme Court basically said that the attorney-client privilege applies to the entire corporation, all of the employees, if communicating with counsel, knowing that they are, in doing so, helping to provide legal advice, to obtain legal advice from company counsel, that will all be shrouded in the privilege. And it was, the Supreme Court was overturning in a decision of the Court of Appeals, which applied more of a control test to the privilege, that the privilege would only pertain to those corporate employees who are instructing corporate counsel. So much broader, Upjohn applies, attorney-client privilege applies to the entire company. And so what developed after Upjohn is first a model rule, 1.13, a different provision of 1.13 than the one Erica mentioned earlier, which says that a lawyer dealing with an organization's directors, officers, employees, etc., must explain the identity of the client, who is the client, i.e. it's the company, when the lawyer knows or should know that the organization's interests are adverse to these officers. Now, that's what the rule says, but the warnings that we all in this room typically give are broader than that. It's my practice, and I suspect it's all of your practice, to give the warnings not only to those employees whose interests are adverse, we know or should know that their interests are adverse, but to be more conservative about it and to give the warnings to any employees that are interviewed. And the warnings are typically advising the employee that the company is the client, that the attorney does not represent the witness, but only represents the corporation. The corporation is the client. That the privilege belongs, the attorney-client privilege exists, but it belongs to the company, and the company can waive the privilege. And that the witness should keep the communication confidential so as to preserve the privilege on behalf of the company. Sort of the basics of the warning, I think. In terms of whether, your second question, Zach, in terms of whether the Yates memo affects Upjohn, the Upjohn warning, again, reasonable minds can differ, but some have argued for an enhanced Upjohn warning, which would essentially more explicitly warn the employee that he or she may be subject to prosecution, he or she may be referred to the Justice Department or to the SEC or whatnot. My view is that is probably not the best course, because I don't think it serves the interests of the client well, the client being the company. Because the idea of the interview is to get the employee to talk, right? The company is conducting an internal investigation. It needs the information that the employee has. We have to give these warnings, but A, we should do so in a way that's not too heavy-handed. Even the warnings that I've just articulated can be done, when done poorly, can be done in a really heavy-handed way that scares the bejesus out of the employee, and they'll never talk, right? So there is some art to giving the Upjohn warning, as basic as the principles are. I think there's some art to doing it in a way with some people skills, soft skills, that doesn't scare the hell out of the witness and allows them to talk. If we use an enhanced Upjohn warning and raise the threat of prosecution, turning you into the government, et cetera, as I've seen some articles suggesting, you really minimize the chances of getting those employees to cooperate, which really hurts your client, the company. So in my view, in my practice, I've not altered my Upjohn warnings because of Yates at all.
So, Judge, even when artfully given, those Upjohn warnings sometimes inevitably cause the witness to look back at the lawyer and say, do I need a lawyer? Right. And Model Rule 4.3 basically prohibits corporation counsel from giving advice other than the advice to secure a lawyer. Are there pitfalls to even doing that for corporation counsel, suggesting that a witness should or shouldn't get a counsel?
Yeah, I think so, and I think Billy kind of touched on some of this. There's an opinion from the New York City Bar Association, which is, if you haven't read it, I don't know whether it's been superseded. It's not new. It's from 2004, 2004-02, available on the website of the New York City Bar Association. that kind of cautions against, after giving the Upjohn warnings, suggesting that that someone, an employee, get separate counsel because of the potential conflict between the duty that the lawyer owes to the corporation, first and foremost. An attorney must bear in mind that as corporate counsel, he owes allegiance to the entity and not to a shareholder, director, officer, employee, representative, other person connected with the entity. Because affirmatively advising a corporate employee to secure counsel may work against the interests of the corporation, we believe it is appropriate for corporate counsel to be reluctant to render that advice, at least in the absence of the consent of his client to do so. So you, for some of the reasons, the main point of this, I think, is that your first job really, and I say this to lawyers all the time, facts first, law second, right? You want to find out the facts. And it may be wise to err on the side of caution as to whether or not an individual is adverse. But if you don't have the facts to actually make that determination, then you're scaring them, you're pushing them away. You may delay the ability to get facts because the time to get counsel is going to complicate that. If you're dealing with an FBI raid of your offices that day and you're trying to sort it all out, that may not be the best strategy. And I wonder, kind of whether or not you're sending the wrong message to the regulators or law enforcement. I was a prosecutor for 14 years. If I had two sets of FBI agents out in front of my office, and one group said, yeah, the general counsel invited us in, we interviewed all the employees, and the other group says, yeah, everybody lawyered up, and I can't find out anything. Well, which, I'm going to smell blood in the water, and I'm going to take the second group, right? So, and then there's, the practitioners here can inform me about how this actually works, but just what you say or how you say it, as Billy has suggested, is important. You don't want to suggest to someone who's ultimately not adverse that you distrust them, because you want them on your side when push comes to shove. And then I had a case where a lawyer went in and basically reassured them, gave the Upjohn warnings, and then told all the employees that the business practices had been changed and that they could go about their job. So I ultimately had to throw that lawyer off the case, disqualify them because they became a witness because those employees were not doing the right thing. They were all, in fact, violating the law. So it's, it's a very tricky thing that requires the good judgment of my colleagues here on this panel that has pitfalls and dangers on either side.
Yeah, no, I've read that opinion. It's worth jumping online and finding it and reading it because it's a good example of how you can get yourself kicked off a case. So let's jump across the border, Billy. We'd be remiss, given the number of investigations these days that cross national borders, if we didn't take a moment and just reflect on these various ethical issues and privilege issues that we've been touching on. What are the specific, from your perspective, and I know you do a lot of FCPA stuff, what are the specific pitfalls that folks should be thinking about right now when it comes to issues of privilege and waiver and regulators when you're crossing those national lines?
Yeah, so I guess the most important thing, it sounds sort of basic, but the most important thing is realizing and remembering that the American way of doing things is not the only way, and sometimes that is hard for us Americans to realize. In FCPA cases, but also in other types of cases, the Volkswagen case comes to mind, more and more countries are jumping into what we call the white-collar enforcement game. The UK maybe was one of the first, but Germany was pretty close behind. Switzerland, Italy, Brazil is going like gangbusters. The Netherlands and several other countries are assisting the fraud section and U.S. attorneys' offices in bringing these cases, and they're doing them cooperatively. So another thing that's happening with greater frequency now than ever in history, literally, is joint enforcement actions being brought. In the FCPA context, the Siemens case was the first one where the Munich prosecutor brought an action coincident with the DOJ and the SEC. But it's been, and there was a bit of a lull in that, but in recent years, especially FCPA cases recently, that's been going like gangbusters. Brazil is maybe the most notable one, with the U.S. and Brazil bringing cases at the same time as some other European countries, and all bringing the enforcement actions at basically the same time and splitting up the pot. Well, 10 years ago, and even less, it was really just a U.S. concern, and then maybe a few years after that, then it became a U.S.-UK concern, and now many more countries, maybe up to 20, 25 countries are in the game, and they want a piece of the enforcement pot, both in terms of bringing the case, bringing the headline, and getting a share of the money. So in conducting these cross-border investigations, we have to think about how the evidence will be admissible or not, what the privilege concerns are in all of the various countries that you're investigating in, and that might launch their own investigation, right? So it can be quite maddening if you've got an investigation which covers 10 or 12 countries and they're all sort of serious enforcement countries. There are plenty of countries in the world, unfortunately really, because we don't have that level playing field we talk about, there still are plenty of countries in the world where that are not getting into the enforcement game, and so you frankly don't have to worry that much about it if you're doing an investigation in those countries. But the ones that might have jurisdiction over that conduct, you do have to worry about. A few, just as, to put a little more meat on the bones, a few things that I've been thinking about lately involving the UK, which is a very common partner for the DOJ fraud section on FCPA cases, the UK's Serious Fraud Office. First, we hear about deconfliction, and the new FCPA corporate enforcement policy articulates the deconfliction idea. Many of us complain about it, including myself. But the Serious Fraud Office has taken this deconfliction notion to a whole new level, sort of deconfliction on steroids, in some cases at least, not allowing any witnesses to be interviewed by the company before the SFO has a chance to interview them. Sometimes the SFO wants several chances to interview them before company counsel can interview them. And in some instances, I've seen the SFO object to the provision of documents to the witnesses before they're interviewed by the SFO. And of course, that's a very common practice in the US, to give a corporate employee the documents that he or she appears on, chiefly emails that he or she is on the to from CC line and saw back at the time of the alleged misconduct. That's very common. The SFO is getting increasingly aggressive in frowning on that practice. And when I say frowning, I'm being a little euphemistic. They're taking an extraordinarily hard line. And I've even seen some cases where they're threatening to claim that if that happens, it could be an obstruction of justice or perversion of justice in their version of English. So really mind-boggling stuff to some of us who have been doing that kind of thing in the US for years, and all of a sudden they're being told that can't happen in the UK. So that's one thing to think about, so as not to cause problems for our clients. And another thing is the privilege in the UK. A recent decision in the UK in the ENRC matter cast a lot of doubt on whether internal investigations are shrouded in the attorney-client privilege to the extent that they are here in the United States. Regardless of this question of partial disclosure that we've been talking about, absent any of that, there's a real question in the UK as to whether the SFO has the right to get your internal investigation notes, memos, etc., even absent any sort of disclosure to the SFO, any sort of arguable waiver. That case is under appeal, and there are plenty in the UK who thinks it will be overturned, but nevertheless, that's sort of the state of the law. So those are two just very specific considerations to think about in the UK. And then as these cases go, multiplying to other countries, we could have different versions of this in every country that's bringing enforcement actions.
A lot to worry about. Sandra, just quickly, any perspective from your seat, from the government's seat, in terms of what defense lawyers particularly should be thinking about or worrying about when we're crossing jurisdictional borders in these investigations?
Look, I can't advise except to say, I'd say two things that I just think are important that I'd like to say to this group, which is one, we, the government, the fraud section, we're cognizant of all of these challenges, the things that Billy is touching on and more, privilege, data privacy, quote unquote deconfliction. It is challenging, and the more sort of first world, sophisticated jurisdictions that get involved, and that's happening more, and that's a good thing in ways that Billy mentioned. It's a good thing that these countries are standing up, and some for the first time sort of stepping onto the global stage in the corruption space to really do something for their country and turn things around. But that can make things certainly more difficult. And the second and related point is that we are also encountering a lot of those difficulties on some of those same topics. And for every sort of success story that we have, and particularly in the FCPA context with, Odebrecht or Rolls-Royce or these, Keppel most recently, there are a lot of success stories that involve cooperation and collaboration, although I would be careful, they're not joint. I know that word was used at one point, they're not joint. There are frustrations and challenges that we encounter as well, because at the end of the day, we all have different systems of law. Sometimes they overlap nicely and allow us to proceed and allow us to collaborate effectively to the point where, almost seemingly impossible is achieved, that, jurisdictions all over the world can be resolving one, matter on the same day. But at the end of the day, there are really sometimes competing systems of law, and therefore ultimately sometimes competing objectives. But we try really, really hard, believe me when I say that, not just on bigger issues about, piling on and a fair sort of division at the end of the day, but these sort of day-to-day practicalities that can make responding to an investigation for a company that spans the globe really challenging.
I do believe you, even if Billy doesn't.
Okay, thank you. Got one vote.
And I think the ultimate takeaway is you have to be cognizant of these complexities, growing complexities when you're dealing with international cases. Let's flip again and hit another topic quickly. Lawyers as gatekeepers and whistleblowers, which is a recurring theme, but particularly in the SEC context. Erica, the SEC has its own rules and SOX rules about lawyers as gatekeepers, as whistleblowers. You want to talk for a minute about those issues from an SEC enforcement perspective?
Sure. So in the wake of Enron and WorldCom, Congress passed Sarbanes-Oxley, and Section 37 of Sarbanes-Oxley requires the SEC to establish rules, minimum standards of professional conduct that govern attorneys who are appearing or practicing before the commission in the representation of issuers. And so in 2003, the SEC promulgated Rule 205 under Section 307, and that rule really provides that attorneys who become aware of evidence of a material violation are required to report up the ladder to the chief legal officer, or the chief executive officer, or a qualified committee of compliance professionals within the organization. And the SEC had an objective standard for determining what a material violation was. They defined it as credible evidence based upon which it would be unreasonable for a prudent and competent attorney not to conclude that a material violation had occurred or was about to occur. The rule also requires further reporting up the ladder if the attorney, when they report to the CEO, CLO, or that committee of compliance professionals, doesn't receive what they determine to be an adequate or appropriate response. That means that the misconduct they believe is still going on, or the attorney isn't convinced that they were wrong in making the allegation. And in that case, the reporting up needs to be to the audit committee, or a committee of independent directors, or even to the board of directors. And then what's interesting is under the rule 205.3D2, permits but does not require in-house attorneys to actually report out to the SEC material violations if they've reported up and haven't received any adequate response. And they allow that in three circumstances. One, to prevent the issuer from committing a material violation likely to cause substantial injury to the issuer or investors. Two, to prevent the issuer from committing an illegal act. Or three, to rectify the consequences of a material violation or a legal act in which the attorney's services have not been used. So it's kind of worth noting that I'm not aware of any cases where the SEC has actually brought an action against an attorney for violating Rule 205. in part because members of the SEC's General Counsel's Office have said that attorneys are pretty good, especially in-house counsel, of reporting up the chain, and if they're not getting an adequate response from the CEO or CLO, to reporting to the audit committee or to the board of directors. And so they haven't actually brought, as far as I'm aware, any actions under this rule. Perhaps like just promulgating the rule has deterred people from keeping this kind of information to themselves. What the SEC has also done is under the Dodd-Frank whistleblower rule, one of the exceptions, generally lawyers can't receive any awards under that rule, but one of the exceptions is if a lawyer reports to the SEC pursuant to 205.3D2. In that case, the lawyer is eligible for a whistleblower award if they provide new information that leads to an SEC action that results in recovery of more than $1 million. Now, there are some state regulations and rules that counsels should be actually really aware of that might preclude the reporting out of confidential information. The SEC's taken the position that their whistleblower rule preempts any of those state laws, but that's just something to keep in mind.
Yeah. So whistleblowing to the extreme, ZTE Corporation case out of Dallas recently, Sandra, the general counsel made the decision to go to the FBI with wrongdoing of the parent company of the entity he was working for. Can you just, for folks who don't know in the audience, can you just quickly kind of give some context around that case?
Yeah, and I am cognizant of that we're sort of short on time here, so I encourage people to go and look to this because as I was educating myself a little bit more about it, as one person commentator described it, it's straight out of a John Grisham novel. So needless to say, there's a lot of twists and turns that I don't have time to go over, but in a nutshell, to borrow a law school term, there was an American, somewhat experienced, but probably not experienced enough for the job, lawyer down in Texas who took over as general counsel of an American sub for a Chinese parent company, and that company was the largest publicly traded telecom company in PRC, so a major player. And about a month into the job, the guy situated in the United States who really didn't have a staff and had sort of one liaison who spoke Chinese to report back to the home office, realized that the parent wanted him to work with lawyers to find a legal way to sell their equipment in sanctioned countries like Iran. And fast forward, he went over to China. He sort of said he wasn't on board with doing anything illegal. He ended up ultimately getting subpoenaed by the Hill, and he realized that still in China, he saw direct evidence there that they were violating things. They contemplated openly in front of him, destroying evidence, and he began cooperating, was approached and began cooperating with the FBI. They had, copied his hard drive. But, within not too long of his doing that, a leak occurred. And so he was sort of outed without his specific identity. It was obvious enough, I think Smoking Gun put documents up on their website, obvious enough who it was. And interestingly, he still reported to work. They took his phone, they installed someone across the hall to sort of spy on him, but they didn't fire him, and he sued for a sort of hostile work environment and ultimately reached a settlement. And fast forward a number of years, Department of Commerce and another part of Justice settled with ZTE, with the company, for something like $1 billion. And at the end of the day, the guy, Ashley Jablon, who had been the general counsel of this American sub, had come out and told his story. And this is not somebody who was a key TAM relator. He's not somebody who was an SEC whistleblower who stood to gain. And he has sort of queried, he essentially has said, I had personal, financial, and professional ruin almost. Right. He didn't recover some large sum. It took him a couple of years to find another job. And I think what he said was, quote, you may be the person who just needs to put your hand down and find yourself another job. Yeah. About his whistleblowing experience, sort of putting the fine point on what that experience was like for him and whether it's really worth it. He talked about grappling with the fact that first and foremost, even though the client was dirty, he did feel nonetheless that his job was to protect the client, though right. Clearly here, at least it's in my view, others may disagree, there was basis to report what he knew to the authorities here. But it's a real conundrum for somebody to be
Thank you.
in that position.
Thank you for that very quick synopsis. And it is an important case. And he really was between a rock and a hard place.
Yeah.
And if you read the opinion, you'll get a sense of exactly how and why. In the few minutes that we have left, I do just want to quickly turn to Judge Hillman, because Judge Hillman, I know sort of at the other extreme for lawyers is when you become a criminal defendant. And I know you actually sentenced a general counsel of a company to 12 months in prison last year, I believe. Can you just quickly relate sort of what happened in that case? Any thoughts about, how lawyers can keep from becoming criminal defendants?
Sure. Well, like Sandra, I focused on that line from the article in the ZTE case about Mr. Blanc saying sometimes you just have to find yourself another job. And yesterday in the general counsel session, there was Ms. Dotson, I think from PetSmart, who said, I tell people who aspire to be general counsel that if you take it, be prepared to lose it. So, this case that I had, and I don't know whether Ellen Brotman is here, because I should probably acknowledge that Mr. Gale's lawyer is here in the conference, but in any event, this is a sad example of a lawyer who did not leave when they should have left, when they uncovered criminal conduct at their corporation. This young man had done well at a good local law school, had been hired by several prominent law firms over the course of his early career. And as he told me in his allocution, he really wanted to be his own, to be in charge of a legal department, to be a general counsel, to have a client, to work hard at building the business. So despite the fact that this company, Red Flag, had been raided by the FBI, he decided that he kind of bought the story that the CEO was telling people, that this was all a misunderstanding, all a mistake. Kind of took on the role to kind of manage the crisis. And he came to the jury selection for his boss, sat in the middle of my panel. I had a juror complain about some things that he was doing. I had to throw him out of the courtroom. But what happened was the company, once it received the discovery in the criminal case, sought out to, despite the bail order, reach out to clients of the firm who had been victimized, who were going to be witnesses in the trial, and tape the conversations with them in a way to try to negate them as witnesses or neutralize them as witnesses, and offered them refunds. And Mr. Gale kind of involved himself in that process. Then when the government got wind of it and served a trial subpoena, he alerted the principal to the fact that several of those tapes were probably not, or at least one was not going to be helpful to them in terms of the response from the defrauded client. And sure enough, the CEO, who was not supposed to have anything to do with the production, actually managed it. The production under the trial subpoena was incomplete, and this lawyer knew it to be as such since he signed the certification. So it's kind of a sad story. A lawyer who had 100 character letters and folks who testified on his behalf at sentencing, who found himself really kind of in over his head. And I think the answer, the issue, and I wonder about all these startups out in the world and lawyers who find themselves in these situations and really don't know how to handle it. And I think the answer is, I don't know if many of you probably do read Above the Law, the blog Above the Law. That in the last week or so, they have a very funny chart about, do I need outside counsel? And it's one of these decision trees things. And across the top it says, do you know what the hell you're doing? And if the answer is yes, then there's a bunch of, if the answer is no, then you go rate 2, hire outside counsel. And if the answer is yes, then you go through a couple of other questions, but it all leads to hire outside counsel. So if you're a general counsel here, there's some very talented lawyers here that might be looking for work. And so I think that you got to know where your limits are in terms of that. And the other case, do we have time to the other case? Or probably should just pass.
I think we're actually up on our time,
All
Judge. But look, very much appreciated. And I failed as moderator in not allowing time for questions, but I do think we've covered a lot of really important turf here this afternoon. And I'm grateful to all the panelists for their preparation and being here today. So let's give them another round of applause. Thank you all.